Most legal disputes don't actually need 18 to 36 months. And frankly, neither side wants to be involved for 18 to 36 months.
That's Rich Lee, CEO and co-founder of New Era ADR, a venture capital-backed tech company that saves both individuals and businesses time and money while bringing long-desired but never before seen certainty and predictability to their legal disputes. I'm Germain, the host and producer of the Dear Human Resources podcast. In this episode, Rich is going to talk about an online resolution platform. Welcome, Rich.
Thanks for having me.
How does an online dispute resolution platform differ from more traditional approaches such as arbitration or litigation, especially when it comes to workplace disputes?
There are a lot of differences, and I think the differences are significant, but there are also some similarities, right? I think there's similarities where it matters, and then differences also where, we believe it really matters. So the similarities are that, we're still arbitration, right? Because especially in the US, you need to fit within a framework of long established dispute resolution, legally enforceable dispute resolution mechanisms. And so in the US, where we're primarily focused, arbitration is a long established form of dispute resolution, codified in federal law. Litigation, of course, taking place in court, certainly well established as well. And so on those fronts, right, we certainly maintain, all the pillars of what arbitration needs to be, right, which is there has to be due process, right? There has to be fundamental fairness for both sides. There has to be an exploration of facts and what happened, right? But where we differ isn't just in purely the online part. Certainly online is a big element, but, real quick background on New Era, what we are, and the problem we solve, I think will help give this a little bit of light too, and a little bit of color, is that, the thing we're solving is that in the US, dispute resolution, litigation, just resolving a legal dispute, whether it's a workplace dispute, a contractual or business dispute, it doesn't matter. Resolving a legal dispute in the US, when I say the word lawsuit, right, we all just kind of automatically assume it's going to be an 18 to 36 month process, very expensive, very time consuming, huge distraction, right, to your company and to your personal lives. And that's a product of the existing systems, right, that are currently in place, right? So certainly our court system, and then these legacy arbitration systems that have been around for 50 and 100 years, where they're built to kind of turn over every stone, allow each side to explore and exhaust, right, all procedural mechanisms, right? But the reality is, and this is now getting to where we differ, right? The reality is that most legal disputes don't actually need 18 to 36 months. For example, if you have a legal dispute, right, that requires it, it'd be something like, fighting over who owns self-driving car technology, right? Two companies, or, two companies that entered into some multi-billion dollar joint venture and that relationship going awry. Certainly, I think that deserves a lot of time and attention. It deserves turning over every stone. But the reality is most legal disputes don't need that. And I know this, and my co-founders know this because we experienced it. We were all former general counsel, former top lawyers of companies, and we dealt with employment and workplace disputes, standard business disputes, where, we saw that, like, just given what's going on, you don't need 18 to 36 months to resolve this. And frankly, neither side wants to be involved for 18 to 36 months. Going back to the original question, this is one of the big differences, is like what New Era is we are 100-day arbitration. So you will get to the same outcome and the same resolution as you would in 18 to 36 months elsewhere. But we kind of create a lot of efficiencies, both through our processes, right? So we have a whole set of procedures that are designed to eliminate a lot of the gamesmanship and a lot of the unnecessary procedures that we've encountered, back when we were practicing lawyers, where we said most legal disputes don't need all these different mechanisms to be resolved, right? For instance, exchanging evidence, and for 2 years, certainly you need evidence from both sides, but you don't need to take 2 years or 3 years just to be fighting over what evidence needs to be exchanged, just using that as an example, right? And so we are 100-day arbitrations all online, so 90% faster and cheaper, but more importantly, the same quality people, the same arbitrators and mediators. So we still have a human in the middle. So the same arbitrators and mediators that you would actually find anywhere else. So these same highly experienced folks who are already doing this, at these other arbitration forums, who are retired judges, who are retired lawyers, they really like what we're doing. And so they're joining, our platform as well. And so from a workplace dispute standpoint, the majority of workplace disputes, frankly, don't need 2 to 3 years of litigation. No employee wants that. No company wants that. And so that's where, New Era as an online dispute resolution platform really differs from existing arbitration forums in the courts.
I want to focus a little bit on the relationship part. Many companies want to maintain trust with their employees, right? So even during disagreements, how can your online resolution platform help preserve those relationships rather than damage them?
A great deal, because we address the part that frankly has been the most difficult to address for any company. When you think about employee relations and HR, right, you think about certainly the rules and the employee handbook and kind of the guardrails that you put in place for like what you expect out of employees, the policies, right? Certainly you think about kind of outreach, employee outreach, and people talk about kind of being proactive in employee engagement, and certainly, of course, constantly measuring engagement and satisfaction. And those are all great. And I think what we are is we are almost like that final piece of the puzzle that kind of never existed, right? Which is that no matter how good of policies you have, how strong your handbooks are, or what kind of benefits programs or employee engagement programs you have, right? Disputes are just nonetheless a fact of life, right? And it's a fact of the working place. And so the problem with disputes, and we live this firsthand, and I can give you some examples, but the problem with disputes in the workplace, especially with employees, is that while certainly there's always going to be some sort of outreach initially, and every company that's a good actor will always try and, as it's sensing that something may be wrong with an employee or a dispute's arising, they're going to do their best, right, to try and mitigate that or try and make things right. But there's certain disputes that, sometimes they can't be. But the problem with all of this is that it's underpinned by, the legacy arbitration forums and the litigation. By that, I mean, when the specter of not making things right, or when the alternative to not making things right, and if the alternative is basically 2 to 3 years of highly litigious, highly acrimonious, very expensive, highly distracting, just fighting, that makes it hard for the two sides to kind of have an outlet, right? And to like get to resolutions quickly with these employees. And it affects everything upstream, right? Because when you know that that's kind of the end game and that's the final, you know, option, well then a lot of the things you do leading up to, going into the dispute, whether you're the employee or you're a company, is it's not as open, right? And it's just not as, I don't know how to put it, as candid and, to the point, because then that there are a lot of these games that can be played by both sides, especially, if like each side has lawyers. And so when you change that dynamic, when that final option is no longer 2 to 3 years of like expensive, time consuming, distracting fighting, and it's instead 100 days to the point, designed in a way where, even the arbitrator is empowered to shut down any sort of gamesmanship or people trying to get cute with this process, well, then you get people to the point really, really quickly, right? Both in terms of arbitration and mediation, right? And so just real quick on the two options, arbitration is kind of much like what you see in court, right? There are two parties, they're putting on their case. There's an arbitrator in the middle who is, analogous to a judge who will win, who will call a winner and a loser and say, you know what, I believe this side more than that side, so this party wins. That's the outcome of an arbitration. Mediation is a little softer, right? But also a very effective tool. Mediation is two parties and still a mediator in the middle. But the goal of the mediator isn't to decide who wins and loses. The goal of the mediator is to try and help both sides right? Reach, see the other side's point of view, reach some sort of compromise and some sort of path forward. And so both are very effective when, usually mediation's an intermediate step between like full on litigation and fighting, right? In court and the legacy systems. And so again, this all goes back to when the final option is 100 days and no longer 2 to 3 years. It allows all the parties to be a little bit more candid because they know that, you know what, nowhere in this process are there really going to be games being played, right? And when you kind of take that out and you help the parties get to the point all the way up to like even when a disagreement's starting to brew, that's where the trust really builds because then over time, right, the company, especially the company, can start establishing themselves as, hey, you know what, we're going to just kind of address everything head on. We're not going to try and drag things out, deny things, whatever, because that's the kind of the goal of a 100-day process is it keeps both sides honest. And when both sides are pretty honest with each other and very, encouraged to be candid, well, then trust, kind of builds over time, right? Between both sides.
Can we walk through a real world example, even hypothetically, of how a company used an online resolution platform to resolve a conflict in a way that maintained but also strengthened the employee employer relationship?
Before I kind of give the example of how they used, like a online platform like New Era to resolve a conflict, I'll kind of give you a quick example of, what we used to deal with back when we were lawyers in our companies of what currently takes place, right? Every day across definitely the US, but also a lot of parts of the world. And so, just like any other company, my past companies where I served as general counsel, have dealt with our fair share of employee employment disputes. And what happens is, especially from a company perspective, there's certain disputes that are brought against us, where, at the time you do your investigation, you explore what actually happened, you review the documentation, and you're like, you know what, we didn't do anything wrong. But the problem is, right after I made that determination, I had to go and tell my CEO, hey, we didn't do anything wrong. Our defenses are strong in this case. We would win this if we actually fought it. But fighting it takes forever. So pay the guy, $80,000. Just pay him. Right. And I'd have my CEO look at me like, wait, you just said we would win. Like, yeah, but let me tell you what winning looks like. It's going to take, 2 to 3 years. This is going to be hanging over your head the entire time. And if you don't pay 80 now, you might end up paying 800K just to litigate this thing. And possibly not even, that might not even be enough to kind of reach the end of a litigation. And so do you really want to deal with that? Right. And so this happens every day in companies. Right. And just to kind of give the other side of that perspective real quick too, the same goes for employees. Like how many employees have truly actually been wronged, right, by an organization, but they can't stand up for themselves because it's the same for them. If I want to stand up for myself as an individual, well, now I have to deal with, 2 to 3 years of this hanging over my head. And even if I don't have to pay my lawyer because they only get paid when I win, well, I don't have 2 to 3 years in my personal life to be dealing with this thing, this constant dispute that's just going to kind of keep coming up over and over. So, all right, I'll just walk away. Right. And that's wrong too. Right. And so that's the old world. And so, in the current world, we've seen it. We've seen it hypothetically and we've seen it kind of live where, we have organizations that tell us like, listen, we just want to present something that's to the point. And so companies, the way you adopt New Era, and I think this is important, right? The way you choose quote unquote New Era and you come to us to resolve your legal dispute is in a contract, right? And so in employee handbooks, in independent contractor agreements, in employment agreements, if companies have those with their employees, there's always a clause at the end of every one of these agreements, just like they exist in every contract that you've ever signed or clicked through. It's called a dispute resolution clause, right? And so in that clause, it'll say, well, if we have a legal dispute, we will resolve it in, the courts in Chicago or the courts in North Carolina or this arbitration platform, right? And so people are crossing that out and putting in New Era ADR. And so there's your mutual agreement between two sides to say, you know what, God forbid if something comes up, the contract now says, or the handbook now says, we will go resolve it at New Era. And by virtue of doing that, you've basically, shortened the time to a legal dispute to our 100-day process. And so companies have said, like, we want to switch to this because this is way better for us, because, it's just to the point with these individuals. And if, God forbid, some of these individuals bring, like false lawsuits against us or ones where they're just not true, well, then at least we have a better shot at just resolving this and defending this without just paying the settlement just to make it go away. And that's from a company perspective. But in the same breath, several of our clients, company clients have said the other side, which is, we're also going to tell our employees that we've actually adopted a dispute resolution mechanism in New Era that's objectively better for you as an individual, right? So if we as a company wrong you, this is actually a way better, more efficient forum for you to hold us accountable. And so we want to let our employees know that too. And so we've seen both sides of that, and we've seen, now settlements like based on what actually happened, right? Not settlements based on avoidance of 2 to 3 years of conflict. We've seen settlements based on merits, like what actually happened, get achieved in like actually well under 100 days. Because I think when both sides realize, like, okay, good, neither side is going to play games. I can't play games, and I can't try and, use some of these tactics to drag things out and create pain on the other side. Well, then when they see that neither, when people are coming, again, it goes back to kind of just being candid and direct. When they see that the games aren't available for them to play, well, then they just come to a resolution on their own, even quicker than, before our arbitrator even has to decide anything.
Mm.
So that's already been a really, really interesting observation and, something that we've seen. And it's good validation for us, at least, right? That like this is working. It's working. It's getting parties to the point, and frankly, the most kind of obvious thing is that when you fight for 100 days versus fighting for 2 to 3 years, there's a much higher likelihood that you can at least fight for 100 days and then kind of still maintain a relationship afterwards because you've had that outlet, right? You've had the arbitrator or the mediator kind of tell you, you've had someone else hear your case, right? And you've had the outlet of presenting what you believe is your argument. And a lot of times that catharsis, that's, it's human nature, right? And it's psychology, and that catharsis matters a lot.
For HR professionals who may be hesitant to introduce a tech-based dispute resolution process, what would you say to help them understand the value and ease also of adopting your online tool?
Yeah, well, for us, it's the biggest thing is, letting them know that like we understand technology and really, really well in terms of the user experience, right? And I think, and by that I mean, the tech helps in the areas where, you would traditionally want tech to help. And then, but we still maintain kind of, like I said, the human in the middle, the live arbitrator, the live mediator, because that's also, what people are most comfortable with right now. So this isn't purely like hey, you put in some evidence and some, algorithm in a black box just kind of spits out a decision, right? And so for us, it's letting them know that you're kind of getting the best of both worlds, which is the efficiency and, everything I just said before this question, the efficiencies, the directness, all of that in the form of, the people and the technology, right? And so you still have the same high quality people hearing the cases, right? But then for an arbitration, you no longer, or your company's lawyers no longer have to travel to a physical location, right? Because this can all be conducted online. Also, everything that's taking place across, your dispute resolution portfolio, whether it's multiple mediations, if it's arbitrations going on, well, you can track all that, both like, existing cases, but also have a historical view of like what happened, across everything, that's ever occurred in this business. And so it's basically it's injecting technology where it makes the most sense right now, while keeping certain, parts of the process deliberately a little bit more manual, because that makes the most sense right now. And then, of course, as we then keep evolving, people are going to be more and more used to the platform. And so we'll continue introducing technology in the right way because, all of us come from the tech world. I came from an AI company. A couple of my colleagues came from, e-commerce and like marketplace type technology companies, where, that balance between how quickly you introduce technology and what parts, you choose to not automate right away is actually a really, really important decision when it comes to both like user experience and user trust.
What inspired you to co-found New Era ADR? And what gap in traditional dispute resolutions were you trying to address specifically?
The biggest inspiration was, what I laid out, which is that reality and recognizing that most legal disputes do not need, the 2 to 3 years that are just kind of normal and accepted currently, in the US. We're in all sorts of industries because that gap exists everywhere. I mean, we have clients ranging from, some of the largest banks in the US handling customer disputes to some of the largest real estate organizations to large retailers, even the US Olympic Committee, right? So we're actually Team USA's arbitration provider. So the athletes, vying for spots in the Olympics, they have disputes, right? And same thing there, just like any employee dispute or anything, it's in nobody's best interest to drag those things out and to make those expensive and, just make it painful. Nobody wins, right? And so for us, we recognize that like that's the big gap is frankly, we like to say 99% of legal disputes or any sort of dispute just doesn't need the 2 to 3 years that are pretty much the only option, before we existed.
It sounds like you've identified kind of a brand new business idea. Do you feel that way?
I do. I think it's both a business idea and it's something actually we talk about internally, something that will, we like to think will really benefit society, right? Because when I say that, everything I said can probably be summed up as like fights are going to happen, disagreements are going to happen, disputes are going to happen. The thing is like we just need to learn to fight better, right? And argue better. And this is our version of what we think is better is like, hey, get the parties to the point. Let's get rid of the drama, get rid of the games that people like to play, especially in legal disputes, where they can use court procedures or these legacy arbitration platforms, procedures, and rules and twist them around and create a ton of extra work and a ton of extra expense for the other side. None of that's needed. And so when you fight better and when you argue better and parties get to that resolution, like a real closure, I think just relationships as a whole improve across society, right? Whether it's two companies and, let's say a manufacturer and their supplier, and they have a dispute over parts. Well, let's get that knocked out so that way you can go back to, that partnership. But same with employees and an organization. A lot of times, frankly, when you argue better and when you fight better, there's a world where, hey, that disagreement between the employee and the company may not need to result in this like long, full blown out, acrimonious fight. And it could actually, get resolved quickly. And then the parties actually go back to working together. The employee stays at the company and everybody moves on because everybody had that outlet and everybody had that disclosure. And so, it's a new business idea, certainly. And we saw a really, really big gap. But, there's also a mission to just, hey, let's just improve relationships right across society.
And the bottom line, because you're saving businesses money and time.
Absolutely. Yeah. I mean, and it's not just the funny thing is the money's not just the cost of the litigation itself. It's like everything I described about, the settlements that you pay to avoid, the litigation when you did nothing wrong. It's like,
Yeah.
why did I, and the example I used was a real case. Why did I advise my CEO in my past company to pay $80,000 when I determined that the company did nothing wrong? Well, it's because, if we didn't do that, we might have paid way, way more, but that's wrong, right? And so think about how many of these, unnecessary settlements you would save as well, in addition to, the cost of the actual litigation itself being reduced, right, by 90%.
Thank you, Rich, for being on the show.
Thanks so much, Marie-Lee.
Support for this show comes from Western Carolina University, a campus of the University of North Carolina system, with the technical assistance of Kelly Minnis.